Thanks, Judge.
You're welcome.
All right, Judge Riedler's moderator, and our moderator, I'm sorry, Judge Riedler's career clerk, and our moderator this evening is going to introduce all our guests, and so we'll go ahead and kick it off to him.
Sure, thanks Aaron, and thanks to UC FedSoc for having us. We have a great panel tonight. My name's Andy Nolan. I'm a career clerk on the U.S. Court of Appeals for the Sixth Circuit. I work for one of the esteemed panelists that we have here. I'll get to them in just a second, but I just want to start out just high level. What we're going to be talking about tonight is something extremely timely and timeless. That is the Declaration of Independence as we celebrate its 250th year. I'll say that the Declaration is near and dear to my heart. Before I was a lawyer, I was one of those horrible U.S. history teachers in high school.
Oh, I didn't know that.
Students all memorize the Declaration
Good
of
for you.
Independence. And then when I even became a big lawyer, I was working on Capitol Hill, and I worked out of the Library of Congress, and the Declaration came back into my life. I think we always think of the Declaration being at the archives, but for ages the Declaration was housed at the Library of Congress, and they still have a lot of materials related to the Declaration in the library, including the drafts of the Declaration of Independence. And it's just a small perk of being a government employee. I was able to know a person who knew a person who was able to show me the actual drafts that Thomas Jefferson wrote of the Declaration of Independence. And there's some fascinating stuff if you dig into it. You can look. The original draft had quite a few lines in the grievances condemning slavery, condemning it quite strongly about the king perpetuating the slave trade and preventing abolition. That, of course, got taken out by the southern states during the editing process. There's other things that you see in the drafts. There's a letter from Benjamin Franklin where he advised Thomas Jefferson to change the words, "We hold these truths to be sacred and undeniable," to "We hold these truths to be self-evident." Great editor, made a word economy, which I appreciate in my current job. Probably the most fascinating thing that I remember from looking at the drafts of the Declaration of Independence was you look at Jefferson's draft and you'll see the word citizens used to reference Americans. And then there's right before the word citizens, there's this giant smudge. And you can just tell that Thomas Jefferson, like any of us, was writing something, smudged it out, and then wrote citizens. And apparently it's puzzled historians for ages, and finally they got the technology where at the library they were able to look through different lights, and they realized that the words that Thomas Jefferson used was subjects, and that would have been probably pretty inappropriate for a Declaration of Independence from the King of England. But anyway, all to say is the Declaration of Independence, fascinating document that you learn more and more about every time I look at it, and it has obviously continued relevance in our lives as not only citizens but as lawyers, and that's what we're going to talk about tonight. And we have a great panel to get us there. I'll start from the far left, Josh Blackman.
I'm on the far left, thank you. Okay.
Yeah, there we go.
That's fine.
So Josh is, since 2012, has served as a professor at the South Texas College of Law in Houston. He holds the Centennial Chair of Constitutional Law. Josh doesn't sleep. This is all I can only surmise. He's constantly working. Probably the most impressive thing that he's done of late is he was the senior editor of the Heritage Guide to the Constitution, of which Judge Riedler and myself had a very tiny role, but Josh had to do the heavy lifting of editing an entire volume that'll live on, hopefully for a long time, in constitutional law lore. He's also very familiar with the city of Cincinnati, having clerked for one of the great judges of our country, Judge Danny Boggs.
Great American.
So glad to have you back in Cincinnati. Next to Josh is my boss, so some nice things about him. Judge Chad Riedler, has served on the U.S. Court of Appeals for the Sixth Circuit since 2019. Prior to that, he was the acting head of the Civil Division of the U.S. Department of Justice during the first Trump administration. And before that, he was with the international law firm of Jones Day, where he worked in the Issues and Appeals section and argued in front of many, many courts, including the U.S. Supreme Court. And like Josh, Judge Riedler also started his career clerking on the Sixth Circuit. And last but not least, we have Judge Matthew Byrne, who serves on the Ohio Court of Appeals for the 12th District, where he was elected to in 2020. There's civil and criminal appeals from trial courts in 8 different counties in southwest Ohio. And before that, he was a partner of Jackson Lewis and Taft Stenius Hollister in Ohio, and was a graduate of the Ohio State University Moritz College of Law. So our plan is sort of to start out with some history. Josh is going to help us take the basics of the history of the Declaration and how it relates to the 2 main moments in constitutional law, the initial founding in 1789 and 1791, and then go into the 14th Amendment in 1868. And then we're going to give some perspectives from the federal bench and the state bench on how some modern perspectives on how the Declaration influences our legal regime. So, Josh, you want to start with that?
Thank you. Thanks to the Cincinnati chapter, this is a cool event. We have a very special year coming up. America's 250th birthday. Now, I was not alive for the bicentennial in 1976. I won't ask who was. But this was a very momentous time where all of America came together to celebrate 200 years of independence. And I hope and I sincerely pray that this year will bring us together in similar ways. So there are 3 important dates to keep in mind. We all know July 4th, 1776. This was the day the Declaration was adopted. To be clear, it was probably signed before, after, signatures came all around. We'll just call it July 4th to make it easier. But this was just the start, right? This was merely the formal declaration of separation from Great Britain. It didn't frame our government. To be clear, the Declaration had forms of government, saying we are now a nation, we will conduct peace, we will leave e-commerce, and so on. The next important date came in 1781, where the United States, not the United Colonies, the United States ratified the Articles of Confederation. This was the first attempt, the first stab at a national government. There was no executive branch, there was a unicameral legislature, and there were no fixed courts. This form of government did not succeed. It barely made it 6 years. It was found to be too weak and created too much conflict between the states, and there was no strong national government. The third date is September 17th, 1787. This was the date that the Constitution was signed in Philadelphia. The Constitution sought to remedy the failings of the Articles of Confederation, but it still carried with it the spirit of the Declaration. The next relevant founding, which people don't think about, is the Reconstruction period. In the wake of the Civil War, in rapid succession, we passed the 13th, the 14th, and the 15th Amendments. These amendments abolished slavery, made all men truly equal. The 14th Amendment ensured the equal protection of the laws, guaranteed that states cannot deprive people of the due process of law, and secured to the people the privileges or immunities of citizenship. The 15th Amendment, ratified a couple years later, said you cannot deny the franchise the right to vote on the basis of race. In many regards, the first framing happened in the 1770s, then another framing in the 1780s, and then another framing in the 1860s, were the 3 instrumental periods in American history and constitutional law. What I'd like to talk about today is how the Declaration influenced the Constitution. And there are actually about 20 clauses. Some of you have probably heard of, some of you haven't. 20 clauses of the Constitution that are directly impacted by the Declaration. These were experiences born by our framers. They lived under the rule of the king. They lived under the thumb of colonial governors. And they saw firsthand what worked and what doesn't work. Now, some of these clauses will seem not very important, but I'm going to list them in the order in which they appear in the Constitution. I'll start with Article 1 of the Constitution. So there's something very basic. What happens if a vacancy occurs in the House? Well, there's a special election. That is not guaranteed to happen. In fact, under the rule of King George III, there were no elections. The king would dissolve entire houses of government. So our framers ensured that when in fact there's a vacancy in a house election, the state can then call an election. That's number one. Number two, how does a bill become a law? All right, school us rocks. There's a very formal procedure. It's called bicameralism and presentment. A bill passes the House of Representatives. Then it passes to the senator. And it goes to the president for a signature. The president can veto it, in which case both houses can override it. You all know this. Why do we have this process? Again, this was born from a frustration from the king. The king basically had the power to make law unto himself. He would dissolve the legislatures in the American colonies, and the people could not govern themselves. A common theme was no taxation without representation. It's no surprise then that under a constitution, which branch of government can create taxes? The House. Taxing bills cannot originate in the Senate, they must originate in the House. Why? The House is closer to the people. So the taxation power is closer to that of representation. The third involves immigration. And this is one people don't remember. One of the many grievances against the King George was that he's prevented the population of the states. He's refused to pass laws encouraging migration. He obstructed the laws of naturalization. The colonies were actually pretty empty, and they needed people, and they sought to regulate and stimulate migration. The king did not want to send more people there to make them more dangerous. He blocked off immigration. So it's no surprise that under our Constitution, Congress had this power to establish a uniform rule of naturalization to ensure that the central government had the power to see who was able to enter this country. War. Under the English law system, I can't call it the English Constitution, they don't actually have a constitution. Under the English system of laws, the king could more or less fight wars by himself. And he often did. And the king would often drag countries into war for years upon end. When our framers crafted the Constitution, they sought to do something different. The power to declare war is not vested in the executive and the president, it'd be vested in the Congress. This was an early manifestation of the separation of powers. Next, I want to talk about slavery. So an interesting part of the Constitution is the word slavery appears nowhere in the Constitution. There's a very conscious choice. Instead, they use euphemisms like other persons or such persons bound to service or labor. And one of the provisions of the Constitution that addresses slavery was called the Migration or Importation Clause, or often called the Slave Trade Clause. There was an entire economic enterprise of moving slaves from Africa across the Atlantic to the Caribbean and to the States, the so-called triangle trade. This was a very lucrative business. Many members of the northern states wanted to ban the slave trade outright. Southern states said, don't ban it. So a compromise was reached. The compromise was this. We won't ban it to the year 1808. Give it 20 years, see what happens. Indeed, it was banned. But it's important to remember, and actually Andy alluded to this before, the Declaration originally had language about slavery. Thomas Jefferson wrote a draft, and he called slavery execrable commerce. He said slavery was a cruel war against nature itself. But as Andy mentioned, these phrases were dropped out. So in many regards, the evil of slavery was recognized at the time of the Declaration, was understood at the time of the Constitution, but wouldn't be remedied till the Reconstruction Amendments in 1865. Okay? Another clause of the Constitution you probably never heard of, called the State Treaty Clause. Who knew this was there? States can't form international treaties. Only the central government can. Why is this important? Because one of the failings of the Articles of Confederation was that states became mini nations unto themselves. The Declaration itself said that we are now the United States of America. And I want to just pause on that for a moment. Today we would say the United States is a country, is, singular, right? But that's not how it was viewed at the framing. You would say the United States are a country, that the states collectively. So it's more of a modern notion of having a single republic. These were a group of states. And the Declaration explains the United Colonies became United States. They were states that were united, but it was not a cohesive whole. All right. But halfway done. Let's move on now to the executive. One of the greatest evils of the king was the power over offices. If you read Federalist 69, Hamilton wrote, "The King of Great Britain not only appoints its offices, but creates them." And the Declaration says the crown has erected, I still love this phrase, a multitude of new offices, and sent hither swarms of officers to harass our people and eat out their substance. What were they talking about? Tax collectors. They would search people with so-called general warrants without any probable cause, and they would find what money was due to be collected. The Supreme Court would later say that the king's power of appointment was deemed the most insidious and powerful weapon of 18th century despotism. So under a constitution, can the president create offices? No. Can the president appoint these officers by himself? Generally, no. Under a constitution, for principal officers, like Judge Radler, there's a process. The president nominates, and the Senate confirms. By the way, it's actually a fun question. I'm not sure you're actually a principal officer. They call you inferior court judge. I think you're actually an inferior officer. Could he be appointed just by the president himself by the courts of law? It's a fun question. Souter had an opinion on this one, which he might have been right. Anyway, but you are not inferior in my view. I consider you a superior jurist, if not from an inferior court. Okay, that's number 7. Number 8, adjournment. Whoever thinks about this? The king had the power to adjourn legislatures. He would say, okay, legislature, you're not meeting anymore. Go home. And what happens when they adjourn? They can't pass laws. They can't transact their business. This was actually such a prominent concern that this was put into the Constitution. The president has only a very limited adjournment power, only where both houses disagree. He can then adjourn them to a specific time. But the House can then reconvene on their own authority as they wish. Very important provision. All right, that's it for the executive. Next to the courts. In the 1770s, Great Britain passed a series of so-called intolerable acts. The intolerable acts. These were, as the name suggests, meant to make the lives of the colonists miserable. One of these made a lot of the judges, in Massachusetts in particular, subject to the king's removal. And they would only get paid if they did what the king wants. That's a problem. So there are 2 parts of our Constitution that stem directly from this, which Judge Radler knows well. The first is the Good Behavior Clause, which says the judges shall hold their offices during good behavior. It's not exactly life tenure, but that's basically how it works. So long as he doesn't screw up or do something bad and get impeached, he gets to keep his commission for the rest of his life. Congratulations. This was a direct objection to how the King of England made the judges dependent upon his will. The next one involves salary or compensation. The Constitution says that the judges shall receive compensation which shall not be diminished during their continuance in office. Shall not be diminished. So even if judges issue rulings you don't like, you can't decrease their salary. Now, as Judge Radler will agree, there's no increase guaranteed either. There's no guarantee. You don't get a cost of living adjustment as a judge, at least by the Constitution.
Hypothetically, if the government shuts down, I think we still get paid.
Yes, so he's still drawing a salary.
I hope everyone else does too, but at least we have constitutional protection.
And your law clerks too. I think your clerks get paid too, right? Right, Andy? Yeah, thank God. Yeah. Okay. So this again, guaranteed tenure and fixed compensation. These are essential components of rejecting the English model of judging. Next, criminal trials. It was a very common practice for the king to deprive people of the right of trial by jury. Our Constitution guarantees that for all criminal cases. It's right there in Article 3, Section 2, Clause 3. What about treason? What is treason? Well, it's very hard to define. And it was a very common practice in England to basically accuse people of treason for just opposing the crown. In our Constitution, this wouldn't work. Treason is defined as leaving war or adhering to the enemies and giving them aid and comfort. It's a fixed, defined offense. And you must be convicted on conviction of 2 people, 2 witnesses, in open court. You can't have these secret proceedings for treason like in the Star Chamber. All right. Next, let's jump to the Bill of Rights. Many provisions of the Bill of Rights stem directly from the grievances against the king. That is, the king denied certain rights, we will enshrine these in the first 10 amendments. One of which is the right of petition. The right to petition for grievances, redress of grievances. The Declaration of Independence was basically a petition. I call it a legal brief, right? It's saying, here's our problems. Here's the remedy we want. It's a petition. It says, in every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. Okay. The Third Amendment, everyone's favorite amendment, is quartering troops. This stems directly from the Intolerable Act, which forced the quartering of troops in American homes. And this is one of the grievances listed in the Declaration. Grand jury. Okay. The Declaration observed that Britain protects its soldiers. They give the soldiers a mock trial. They weren't really tried. For example, the Boston Massacre. People say that might have been a mock trial. So here in our system, even soldiers are subject to the grand jury requirement, except in certain circumstances. The Vicinage Clause. Who's ever heard of the Vicinage Clause? This says that in a criminal prosecution, you enjoy the right to speedy public trial by a jury in the state and district where the crime was committed. That is, if you're charged with a crime in D.C., you can't be indicted in Alabama, right? Okay. What did the king do? He would very often have crimes that were charged in America, and the trial was held in England. Who was your jury? A bunch of Brits. Not a fair trial. There's also the concept of the civil jury trial clause, right? In our Constitution, you have a right to civil jury with $20 amount in controversy, not a very high amount, but still in the Constitution. And this was a direct response to the King of England depriving us of trial by jury. I have some more notes in the Reconstruction Amendments. I'll pause those till later and turn over to my dear colleague to the rest of the panel. Thank you all so much.
So I think at this point we actually can shift to the Reconstruction.
Let me
Do you
keep
want
going?
to just real briefly
Let's go.
touch on it? Like you're on a roll, and you can talk about how the Declaration influenced the second great constitutional moment.
I'm on a roll. I can't stop with that one. So the Declaration presents a tension, right? And Thomas Jefferson understood this tension intrinsically. It says at the beginning that all men are created equal, that they're endowed by the Creator with certain inalienable rights, among them life, liberty, and the pursuit of happiness. But the very moment this was being written, slavery was lawful in most of the states. How do you say that all men are created equal when you have this institution of slavery existing throughout the nation? So there's a couple ways of looking at it. One way is kind of like the 1619 Project saying, well, the Declaration of Independence was garbage, right? They're a bunch of hypocrites. We should reject this and say that these were hypocrites and we shouldn't give any credence. And I take a different perspective. When you write something down on paper and you sign it, you're saying this is what's correct. And even if you're not doing it, you're setting a standard of what ought to be happening in the future. So for the decades and decades after independence, abolitionists would hold the Declaration and say, this is our goal. We wrote this down. We agreed to it. We read every July 4th. This is what we should be doing. And I'm sitting here in the beautiful city of Cincinnati. It's a perfect place to talk about this. Now, I know there's a William Howard Taft statue up front, but I'm talking about Salmon Chase, the law school across the river, named after him. Salmon Chase was a prominent abolitionist. Cincinnati was a hotbed of abolitionism. Newspapers were founded here by freedmen. And they all cited the Declaration. In fact, people said, the Declaration shows that you cannot have slavery under the Constitution. The framers didn't even use the word slavery in the Constitution. You had Frederick Douglass, Lysander Spooner, and others who all preached this message. And in the darkest days of slavery, the Declaration was kind of a source of light that maybe one day we can get there. And it would take a bloody, gruesome civil war, North versus South, brother against brother, to vindicate the promise laid down by the Declaration. As the war was ending, Abraham Lincoln, the president, the great emancipator, made it his cause to pass an amendment, what will become the 13th Amendment to the Constitution. In fact, it passed shortly before his death. And it says neither slavery nor involuntary servitude, except as a punishment for crime, shall exist in the United States. In one fell swoop, this opinion basically nullified the Dred Scott decision. Dred Scott argued that not only is slavery permitted, the Constitution requires slavery. What was the argument? Get this, ready for this? The Constitution says you can't be deprived of property without the compensation of the government, the taking. Tawney wrote, well, slaves are property. If we take away your property, we have to pay you. So actually, laws banning slavery in the territories were unconstitutional. They were taking your property. Insane holding, crazy holding. But the worst part of this holding is Tawney said, this is what the framers understood. This is in the Constitution. And it's simply not there. He had to say the Declaration didn't mean what it said. So the irony is that people today who criticize the Declaration are lining up with Roger Tawney. The 1619 Project reads the Constitution the same way Tawney read it, not what you might think. But I'm with Salmon Chase, who's an icon of mine. I love Chase. I'm very happy I'm in Cincinnati right now saying this. I love Chase. He defended abolitionism. He defended runaway slaves. He argued the Fugitive Slave Act was unconstitutional. And you know what? He became the Chief Justice after the ratification of these amendments. And he presided over a court. Now, Professor Bryant mentioned we'll be teaching about the civil rights cases later. Things went downhill, but at least for a few years, things were looking pretty good. So that's the 13th Amendment. The 14th Amendment was an absolute and full repudiation of the Dred Scott decision. So you mentioned earlier the word subjects was in the Declaration. Another word is citizen. What is a citizen? Who is a citizen? What makes a person a citizen? The Constitution, as originally framed, didn't define citizenship. It referred to citizenship. For example, to be a member of Congress, you had to be a citizen for so many years, right? But how did you become a citizen? Congress passed laws involving naturalization. What about people who were born here? The core holding of Dred Scott is that people of African descent could never be a citizen, that they were inferior, that they could never have that right. The 14th Amendment nullified that holding. Section 1 begins, all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and the state in which they reside. Right up here, yeah. Everyone, if you're born here, you're a citizen without regard to your race. This was sort of fulfilling the promise of the Declaration. And it goes on. No state shall deny to any person the equal protection of the laws. Now we think of this today as like, okay, yeah, that means you can't treat people this race, different people that race. That wasn't what that meant, not even close. Equal protection of the laws meant the law would protect you equally. This is Professor Chris Green's theory. Oh, actually, now at Ohio State, at the Salmon Chase Law School. No, at the, what's the one at Ohio State called? No, yeah, they have this new program. It's the Chase Center. Yeah, the Chase Center, I'm right. Yeah, it's Moritz, but the Ohio State, I'm sorry. Sorry about that. Whatever.
I went to Michigan. So
yeah, I went to Penn State. There's no love.
Bother me.
I went to Penn State. No love at this table.
I went to
All right, I'll give it to you.
Undefinitely.
The O. But the purpose of this clause is to protect people, right? What was the grievance of King George? He wasn't protecting his people. He was letting his people be subject to attack from within and without. The first purpose of government is protecting people. John Locke said it very well. We enter government, we enter this civil society, why? For protection of our rights. That's why we have government, right? That's why government exists. Otherwise, we'd just be running around having a blast. We need government protection. But in the wake of the Civil War, people were not being protected by the government. Indeed, the exact opposite was true. Lynch mobs, the Klan, aided by the government, would kill, murder, and slaughter the freedmen. This provision says you're guaranteed equal protection. The law will protect you. This was a direct response. Then we have this concept of the Privileges or Immunities Clause. No state shall make or enforce any law that abridges the privileges or immunities of citizens of the United States. What are these privileges or immunities? These are rights. These are the inalienable rights the Declaration spoke of. These were the privileges or immunities that the states now were required to protect. Unfortunately, in the case called the Slaughterhouse Cases, very bad decision, very wrong, I think. Maybe Professor Bryan agrees, I'm not sure. He's nodding, good. The court basically eviscerated this, said, well, these rights are not very important, some national rights, but most rights not protected. And then the due process of law, right? This goes back to Magna Carta, that when the government acts, they must act according to something greater than the government. Due process of law, what process are you due under the law? That there's something above the king, there's something above the governor, above the president, that he must comply. The law cannot be will, cannot be arbitrary, capricious, avarice. And now the states are required to honor this. I can talk all day with the 14th Amendment. I have talked enough. Andy, am I done now?
I think you're done.
All right, I'm done. I'll come back later. I'm not
I
done.
do say it's impressive. In like 25 minutes, you've just summarized all of American constitutional
Yeah,
law.
yeah.
And then the important thing is that you have the parallel of the Declaration as this promissory note. And I think that's a great segue to what Judge Raylor's going to talk about.
Please.
Is how has the Declaration and the law that it yielded shown itself up in federal courts in the time since.
Go ahead. Judge?
Yeah, it's great to be here. Again, Chad Raylor, I'm a judge on the Sixth Circuit Court of Appeals. I'm sure you all know the 4 states of the Sixth Circuit, no test, but Michigan, Ohio, Kentucky, and Tennessee. But you probably know that our the seat of court is in Cincinnati.
Over there.
So
Right by Graders.
So Andy and I get to come down 7 times a year to hear cases. We had some panels who heard cases here at the court or at the law school a couple of years ago. So hopefully, if there's an off day, you want to come down to the court, please let me know. We'd love to have you watch some arguments, and it's great to be at the law school as well. So as Andy mentioned, I'm going to reflect on some sort of 20th century developments. How did the Declaration fare? Sort of the principles announced in the Declaration. How did they fare during the 20th century? And my assessment is that all too often the Supreme Court or those seeking to influence it have really fallen short in honoring the foundational themes in the Declaration. And I'll give you I don't have 20 examples, but I'll give you 3 from the last century that I think will help demonstrate the point. So at its core, the Declaration prioritized individual liberty. It recognized life, liberty, and the pursuit of happiness as 3 unalienable rights, and announced that governments derive their just powers from the consent of the governed. The Declaration's drafters thus viewed a government of limited powers as essential to safeguarding individual freedoms. One way of preserving liberty was through a decentralized government, one that acts via elected officials, not unelected judges. In the words of legal scholar Raoul Berger, an early originalist, he said that the Declaration emphasizes that government is founded on the consent of the governed. The terms of that consent are spelled out in the Constitution. Substitution by the court of its own value choices for those embodying the Constitution violates the basic principle of government by consent of the governed. Now, how did these principles fare during the FDR administration? President Roosevelt's New Deal sought to dramatically reshape the role of the federal government, moving it well beyond the limited purpose of protecting individual rights. In a nutshell, the New Deal sacrificed individual liberties in favor of government regulation, with the goal of redistributing wealth and income and massively expanding government reach in areas of employment, housing, and education. But before those efforts could be completed, the Supreme Court was asked to intervene and to limit the federal government's reach by, of all people, a farmer in Ohio. You may already know the story, especially if you've taken constitutional law. The Agricultural Adjustment Act of 1938, a centerpiece of the New Deal, made price supports mandatory for certain crops to maintain a sufficient supply. The law also imposed quotas on farmers and producers to keep supply in line with demand. Roscoe Filburn, a farmer living outside of Dayton, was growing wheat to feed his animals. When Filburn grew more wheat than the per acreage amount permitted by the Act, the Department of Agriculture ordered him to pay a penalty. He responded, as we regularly do now, by filing suit
Mhm.
in federal court, making an entirely reasonable argument. Under its Commerce Clause authority, Congress could regulate only interstate commerce. Yet Filburn's wheat never left his farm, meaning it never traveled interstate. And more fundamentally, the wheat was never sold, meaning it was not even commerce. Ultimately, the Supreme Court disagreed. In its groundbreaking 1942 decision, Wickard v. Filburn, the court held that even if Filburn's activity be local, and though it may not be regarded as commerce, it may still, whatever its nature, be reached by Congress if it exerts a substantial economic effect on interstate commerce. The Supreme Court decided that Filburn's wheat growing activity, while itself not substantial, if viewed in the aggregate through the lens of thousands of other farmers like Filburn, reduced the amount of wheat on the open market, which was substantial and thus fell within the Commerce Clause's scope. Now, as numerous historians have observed, following Wickard, Congress's commerce power in effect became the national police power, rejected by the framers. Going forward, Congress could use the commerce power to legislate for virtually any reason, allowing the federal government to achieve objectives otherwise unobtainable through the Constitution's enumerated powers. That state of affairs evokes the Declaration's complaint that Josh mentioned earlier, that the king had, quote, erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out our substance. Josh referred to those as tax collectors, but I think they could be viewed as, government regulators more broadly. In many ways, the regulatory powers afforded Congress by the Supreme Court authorized the very same conduct, this time, again, by our own federal regulators. Now, another tenet of the Declaration is its pronouncement that the colonies, quote, are and of right ought to be free and independent states. The Declaration called out the monarchy for suspending our own legislatures and declaring themselves invested with power to legislate for us in all cases. At bottom, the Declaration recognized the importance of self-governance at the state level. But courts can take away the authority of state legislatures by making rights flow from courts rather than the voters. And that is exactly what happened in America in the 1950s and 1960s. In a series of decisions, the Supreme Court, in what came to be known as the Warren Court, reflecting the name of the then Chief Justice, interpreted the Constitution in a way that curbed a state's power to make decisions for its citizens, thereby reducing the citizens' right to self-governance. Those decisions spanned many areas of public life, from whether a state could allow prayer in public school to how states could apportion voters for legislative districts. Some of the most notable curtailments of state autonomy, however, arose in the area of criminal law. One example is the 1961 decision in Mapp versus Ohio. And you might be sensing a theme here with my emphasis on cases from Ohio. In Mapp, the Supreme Court addressed what had come to be known as the exclusionary rule, which the court had previously located in the Fourth Amendment's prohibition against unreasonable searches and seizures. Without a clear textual basis, the court held that the states were bound by the rule, which prevents a prosecutor from using evidence that was obtained in violation of the Fourth Amendment to convict a criminal defendant. Doing so, however, limited the ability of states to make their own judgments as to law enforcement. As my colleague Chief Judge Jeffrey Sutton noted in his book, 51 Imperfect Solutions, at the time of Mapp, about half the states had adopted an exclusionary rule, but others had not. Rather than letting states continue to operate as laboratories of democracy, the Supreme Court federalized the rule, sweeping local autonomy to the side. Perhaps like an English king, the majority justices, in the words of the Declaration, declared themselves invested with power to legislate for us in all cases. Now consider the 1962 case of Robinson versus California. In prosecuting drug cases, California prosecutors often had ample evidence that a person habitually used drugs, but little evidence of any specific instance of use. So the state legislature expanded its misdemeanor drug use law to prohibit being addicted to drugs, meaning one could be convicted if the state proved beyond a reasonable doubt that the accused used drugs, quote, often or daily, even in the absence of any specific instance. Casting aside the state's effort to plug a hole in its drug enforcement laws, the Supreme Court held that criminalizing the habitual use of drugs violated the Eighth Amendment's prohibition on cruel and unusual punishments. Now, previously, that prohibition had been taken literally as a ban on certain forms of punishment, say the guillotine. But in Robinson, the court deployed the Eighth Amendment to govern what states may punish. In other words, states were now categorically barred from enacting certain criminal laws. Although criminal law is in many ways the ultimate reflection of a community's values, the Warren Court routinely nationalized the area by imposing constitutional limits upon what conduct a locality could criminalize. The signers of the Declaration, however, would surely have viewed state legislatures, not an activist court, as the proper defenders of liberty in America. After all, unlike court decisions, the judgments of elected officials enjoy the imprimatur of the consent of the citizenry. Now, up to now, I've highlighted ways in which the Supreme Court's practice of stripping the power of self-governance from the people violates the spirit, if not the letter, of the Declaration. But it does not follow that the Declaration encourages the people to retaliate by stripping power from the judiciary. An independent, neutral judiciary is essential to the Declaration's vision of limited government by the political body. Recall the Declaration's complaints that the king, quote, has obstructed the administration of justice by refusing his assent to laws for establishing judiciary powers, and has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. This objection arose from the ongoing struggle for judicial independence from the arbitrary executive will of the Crown. Over the centuries, English common law judges pushed back on the Crown's primacy, asserting their duty to follow the law above the will of the king. By 1701, this long struggle had resulted in an act of Parliament guaranteeing judges tenure during good behavior rather than at the pleasure of the monarch. In the colonies, however, King George maintained judicial tenure at his pleasure. The Declaration targeted this practice of allowing the king to rule the colonies by his arbitrary executive will. Echoing the Declaration, the Federalist Papers likewise emphasized the importance of judicial independence through life tenure. Federalist 78 noted that the Declaration recognized that the people enjoy the right to alter or abolish the established Constitution. But this does not mean that the representatives of the people, whenever a momentary inclination happens to lay hold of a majority of their constituents, may do whatever they please, just as the king did before the Declaration. Rather, a system of government consistent with the Declaration requires an independent judiciary, with no, quote, danger of an improper compliance to the political branches of government. Yet the 20th century produced an episode in which the Declaration's promise of an independent judiciary came under attack through attempts to change the court's size for political reasons. The push for court packing, that is, the manipulation of the court's size primarily to change the ideological composition of the court, represented a sharp divergence from the Declaration's theme of limited government. In 1937, President Roosevelt, frustrated by certain court decisions invalidating his sweeping New Deal legislation as outside the powers of the federal government, proposed legislation that would add 1 seat to the court for every justice over the age of 70 who refused to retire. In effect, this would have taken the court from 9 to 15 judges. The utter lack of historical support doomed Roosevelt's court-packing plan. This is perhaps no surprise given how fundamentally our nation has rejected threats to judicial independence since the Declaration first complained of King George's attacks. In many respects, Roosevelt's efforts were, in a way, the same as those of the king, who sought to rule by will rather than law. In view of Judge's life tenure, the attack on judicial independence could not take the same form as that in England, where kings remove judges at their pleasure. But the effort to remake the Supreme Court itself into a more subservient institution in the wake of an adverse ruling reflects exactly the same instinct for rule by executive fiat, one the Declaration squarely rejected. These 3 episodes, the Supreme Court's blessing of the expansion of Congress's national regulatory authority, the Warren Court's policy making at the expense of the states, and Roosevelt's attack on judicial independence, each represent, in my view, the same fundamental struggles captured in the Declaration. As we move towards the 250th anniversary of that beginning, it bears reminding that our nation's founding was at bottom the embrace of liberty.
Well, thank you, Judge. So we went from 20 examples to 3 examples. I promise you we won't limit you to this one example. Judge Byrne's going to talk to us about his perspective with the state courts and how the Declaration has influenced its role.
All right, well, thank you. Professor Blackman, I think rightly exempted Judge Radler from being an inferior officer, but I'm a state court judge, so not a U.S. Official, but I'll take the inferior title. Thanks for having me here. I think this is my 3rd time speaking at the UC FedSoc chapter. I've been involved in FedSoc my whole legal career. I was a student leader too, and Cincinnati chapter president, large chapter. And it's a wonderful organization. I'm glad you're all involved. I want to talk a little bit about, I think, how the Declaration's promises about rights have manifested themselves in states over time. If you look at the language that Professor Blackman quoted, which we all should know, and all teachers should have their students memorize from the preamble, the Declaration says that we have certain unalienable rights, and among those are life, liberty, and the pursuit of property. And it also says that they come from their Creator, which is an interesting, I think, tidbit that I have to address briefly. Whether you are specifically religious as a Christian, like some of the founders were, whether you're more generically spiritual, like some of them were as theists, or you're non-religious, a member of another religious tradition, there is this idea very clearly embedded in the Constitution, in the Declaration of Independence, that I think Americans internalized over time. That it's essentially if I can be a little bit controversial, say it's essentially a natural law theory, or a natural rights theory. That the Constitution, or I keep saying Constitution, the Declaration, we don't cite the Declaration much in legal documents, that's my excuse why. The Declaration embodied this, or stated this idea that these rights exist because we are human persons, and we get them, as it said, from a creator. But whatever your approach, the idea is we have these rights irrespective of what legal documents or our specific governments at the time say. The idea ultimately, as I understand it, is we have those rights even if we repealed every bit of the Bill of Rights today. Our idea is, well, we have those no matter what the government says. And that's a powerful idea that I believe has affected states over time and individual Americans in deep ways. You can see it reflected I would argue, in the 9th Amendment. When the debate over ratification happened and there was concern about rights not being included in the Constitution, and there were kind of promises about, well, maybe we should pass a Bill of Rights to make sure that these rights are clear, and yet there were concerns about, well, if we enumerate certain rights, are we then saying those are the only rights that exist? And the 9th Amendment is the answer to that. It essentially says that the enumeration of certain rights does not mean that there are not other rights out there. And that idea, I would argue, is behind, in part, what ultimately led to the 13th Amendment, as Professor Blackman was talking about. The 13th Amendment was enacted in the late 1860s. Our state constitution was, the second one, was adopted in 1851. And that language included language that is almost identical to the 13th Amendment. It says, there shall be no slavery in the state nor involuntary servitude unless for the punishment of crime. There's one very minor wording difference and one comma difference between that and the 13th Amendment. But it goes back further. The same language is in our 1803 Constitution, almost word for word. But it goes back further than that. The same language, almost exactly word for word, was included in the Northwest Ordinance that set up the first government for the territory that eventually included what is now Ohio. And there's, I never took Ohio history in school because you do that in like 4th grade, and we lived in Alabama at the time. But I've tried to get myself up to date on Ohio history now that I'm an Ohio elected official. If you read David McCullough's book, The Pioneers, it goes into great detail about Manasseh Cutler and his involvement in from Massachusetts in drafting and coming up, negotiating the language that led to the Northwest Ordinance, and included this language about banning slavery. But that language, importantly, in the Northwest Ordinance, it's worth noting, was passed by the Confederation Congress before the U.S. Constitution was adopted. I would argue that he was influenced by the idea that there are rights that we have, whether they're enumerated by government or not. And one of those certainly was, he would view, the right not to be a slave. That idea planted a seed that, if you talk about a promissory note, I think started to get paid, at first at the Northwest Territory level, and eventually by a state and other states that did the same thing in their state constitutions. And that idea continues today in some respect. We have had in the 20th century, and especially in the 21st century, a greater emphasis on state constitutions. You had Justice Brandeis's discussion of states as laboratories in 1932 in Lieben decision. You had Justice Brennan's discussion of the importance of state constitutions and the opportunities they presented to recognize additional rights in a very famous Law Review article in the 1970s. You then had the 2000s and 2010s and 2020s, where I would argue your colleague and my former state common law professor, Judge Sutton from the Sixth Circuit, has really popularized within the legal profession, but also to some extent even, I should say within the judiciary and FedSoc type circles, but I would say also in the legal profession, the idea that we need to take a new look at our state constitutions, pay attention to those rights. It's an important change, and I'm not sure, you're coming up through law school later than I did, and I'm not sure how much state constitutions are discussed now. They certainly should be. I know early on, my wife's a lawyer too, and early in her career, I remember her telling me about instance, I don't know the details because confidentiality and all that, but a instance where she pointed out as a junior attorney to a senior partner, well, actually, this particular case we have, I think the state constitution includes language that we can use to our advantage. And his response was, who cares about that? Nobody cares about the state constitution. Well, Judge Sutton's tried to change that view, as have many others. And if you look at our state constitution, going back many decades, but even more recently, I think we've taken the idea seriously, particularly because Ohio has a provision where voters can amend the state constitution. That direct amendment procedure makes it very easy to amend. We have had over 132 amendments, I believe, maybe a couple more at this point in time. Some would argue maybe a little too easy, but regardless, it has allowed our state constitution to be amended to recognize sometimes rights that aren't recognized by the federal constitution, sometimes rights that are, but more broadly. These never get discussed, but in Humphrey v. Lane, in 2000, our state Supreme Court looked at our language about religious liberty, the analog to the First Amendment. It's a whole paragraph rather than a couple of phrases in one sentence. It includes language that's very broad and that really hasn't been explored, such as, nor shall any interference with the rights of conscience be permitted. What does that mean? I don't think it's been fully fleshed out, but in Humphrey v. Lane, the court said, the Ohio Supreme Court said that, at a minimum, it provides that laws that even interfere with rights of conscience are unconstitutional under our state constitution. Whereas the federal constitution has been, of course, interpreted more narrowly. And some people would argue that because of Humphrey v. Lane's language, we essentially apply the same test to religious liberty claims that existed before Employment Division v. Smith. If you look at the Second Amendment, I'm just going down the list, I won't do them all. The Second Amendment, Arnold v. Cleveland, in 1993, our state Supreme Court looked at our language that's the analog to the Second Amendment, which has broader language. It says the people have the right to bear arms for their defense and security, and goes on from there. That's a different thing, talking about people's right and security. And at the time, the court, I think retroactively, what we can look back and say is the Ohio Supreme Court said that language meant there was an individual right. It was essentially reaching the same result that was ultimately reached in Heller 15 or so years before Heller was decided. Now, the court actually did uphold the firearm statute in that case, but still, it's an example where our state said our rights are even broader. If you look at the Fourth Amendment, we have two cases, inconveniently both named State v. Brown. Thank you, justices, from 2003 and 2015, which held that the language about the Fourth Amendment and the language equivalent in our state constitution is almost exactly the same. The only difference is one says effects and the other says possessions, and there's a comma that's different. But the court, whereas it looked to text and history and tradition in the first two cases I mentioned, and this one just simply said, we believe that this language is broader than the language protecting the Fourth Amendment language and protects more rights. So in the first State v. Brown, the court held that arrests weren't permitted in certain misdemeanor situations, etc. With the Fifth Amendment and property rights, in 2007, or I'm sorry, 2006, 2005, I was in law school at the time. I remember this being a huge deal. The U.S. Supreme Court said that public use could include taking property to give it to a developer to develop. And there was, of course, a public outcry at that time. And the Ohio Supreme Court, the next year, in Norwood v. Horney, looked at our language about public takings, which is a whole paragraph, and includes language such as private property shall ever be held inviolate, but subservient to public welfare goes on from there. And the court said our language is different. Actually, here in Ohio, you can't take. There was a little exception. Basically, you can't take public property or private property for public use. And there's multiple other examples. The point I'm trying to make is simply that in all of these cases, these provisions were either adopted by one of our constitutional conventions in Ohio or by the voters directly, with a framework that was shaped by the Declaration, a framework that's shaped by the idea that we have rights by virtue of being human. Government exists to protect those rights we already have. And that is really at the center, I think, of our political identity, even in an era like today, where we are so incredibly divided. You can look at contentious issues. Look, what's been a year or 2 years now since the latest state issue 1 passed regarding abortion. I'm not going to get into all of that. But I'll say, just even on such a divisive issue, you have one side that, in the language that was passed, talks about right to reproductive freedom. The other side talks about right to life. Everybody talks about rights because it is central to who we are. Now, I do want to say, I think there's a challenge that we could face. As states are maybe looked to more and more for rights recognition, and there's a reason for that, perhaps. We haven't had an amendment to the U.S. Constitution in 33 years. People seem to forget we have an amendment procedure. It could be used, but it's not anymore. As people look to states more and more, and you start to have states which have more and more maybe noticeable differences regarding rights. This is my personal view. It took me like 17 years to ask Judge Sutton this question because I was too scared to ask him in law school, and I asked him a few weeks ago when he talked to us judges. At a certain point, when you have all these differences in rights, or rights are recognized this much at the federal level, and maybe this much on the same topic in this state, but only here in another state, do we get to a point where people start to think about rights as mere policies or as privileges that can change from state to state? I think that's a challenge potentially in the future, but I'm pretty confident that it's a challenge that can be faced. Just as I said, even when we are a divided country, I think, despite maybe some doubt that was cast on it by a senator recently at a hearing, I think we still fundamentally understand that the Constitution's idea about rights are core to who we are. They're core to what our state constitutions should be and the role of government. And that's, I think, an encouraging thing. Thank you.
So I think we have time for a few questions. I'll have some questions to the panel and we can open it up. But I like that, Judge Byrne, you said we don't cite to the Declaration much, and as a good law clerk, I of course found the section on the Declaration of Independence in the Noack and Rotunda treatise that they have on Westlaw as my first step here, and they have one sentence in it, and it quotes, "Courts rarely cite to the Declaration of Independence, and when they do, it's usually to reference in a passing manner." And I'm just wondering if that's how we should do it. If you think that there is more of a role for the Declaration in constitutional interpretation, if you see it in certain types of judges, I will say, I looked up Judge Rader's cases. This is probably the fault of his law clerks, but there's no citations of Declaration of Independence. But I'm wondering if there should be more of a role for it in our legal discussions and legal opinions.
Yes.
Yeah.
I do. I think the Declaration plays a very important role to understand the nature of rights. Rights don't come from government, they come from God. Right? We're endowed by our Creator with these rights. And I think something we should not forget. You mentioned before, are rights just policies? No, rights are things that we have inalienable. And there's, I think, a conception in modern times to use rights as just entitlements from the government. I think that's just fundamentally wrong. And I think the Declaration repudiates that. And for what it's worth, the Declaration is in the U.S. Code. It's part of our organic law. It is in our law. So it's still the supreme law of the land.
Turn that over to the judges. What do you think?
Yeah, I will try to work that into an opinion at some point.
Work on it.
It's going to have to be the hither swarms line. I'm not sure how we're going to do it, but now that the gauntlet's been thrown down. I would say two things. So the Constitution is our governing document, and I guess I'm a little nervous in one sense to look beyond the Constitution to sort of understand or to just find the sort of core law of what governs our nation. But if you're thinking about how to interpret the terms of the Constitution and you sort of believe in an original public meaning approach to understanding those terms, well, what's relatively contemporaneous with the Constitution? The Declaration of Independence. So I think you could look to the Declaration along with the Federalist Papers and other things to understand sort of how the framers understood certain concepts at the time and how certain terminology was used. And I think that would be fair game in terms of constitutional interpretation.
I agree with that. It certainly shapes how people understand the law and rights and all these things. As Professor Blackman said, he found 20 examples where the Constitution is shaped by ideas that are described in the Declaration of Independence. So it's not, it's not just some statute we look to, but it is certainly, the Declaration certainly provides background and needs to be understood for a full, robust understanding of what American law is.
And you do see smatterings of it in the Supreme Court case law, from all sides. The one person, one vote. One of the key documents they cite to is Declaration of Independence.
Is that Reynolds v. Sims?
Yeah.
Nonsense case.
Yeah,
Nonsense.
exactly.
The Declaration of Independence means anything. It means one person, one vote. No, it doesn't. Sorry.
Oh, that's quite right. But then you see it a lot in I think like Alito cited it about 3 times in a couple of opinions from the last court. So it does have continued relevance for us. One real quick question is, who's your favorite signer of the Declaration of Independence?
Oh my God, who's my favorite child? It's a hard question. God, I might have to pass. I love Jefferson. I think his prose, notwithstanding the editing, was correct. Yeah, I'll go with Jefferson. But there were a lot of really brilliant people who contributed to that.
Can't go wrong.
My daughter goes to the University of Virginia, so I probably am obligated to say Jefferson as well. But I will borrow from one of my colleagues, Judge John Bush, who's writing a book about Gouverneur Morris, who I don't think signed the Declaration, but was a signer of the Articles of Confederation and the Constitution. And Morris was from New York. He was credited with being a wordsmith. He was Madison credited him with writing the preamble to the Constitution, and he was a member of the Committee on Style of the Constitution that made some sort of final edits to the Constitution that likely were quite significant in terms of how the final document read. So, like a good judge, I'll borrow from another judge and take Gouverneur Morris.
Maybe 15 years ago, my father-in-law and I kind of challenged each other he started it, to read a biography of every U.S. president, and I love the founding era so much that I never really moved past it. I didn't get as far as William Henry Harrison, and someday I'll pick it up again. He, laughed at me multiple times, I think, but I love that era. I also find it hard to choose just one, but just for the sheer, I don't know, kind of American, I mean this in the best way, brazenness. You have to admire John Hancock's, the story of him saying, I want to make sure that George III is able to read my signature. It's just a fun story. I think there's a lot of fascinating people who signed it. One thing that, and I don't say this just because I'm personally Catholic, but I think one thing that's interesting is you had Thomas Carroll signed it. He was the only Catholic signer. And I don't say it because he's Catholic, but I say it because, and I haven't even read a full biography of his life, though I'd probably be interested in someday. But I think it's interesting because his presence in a country that really, or colonies that really weren't very favorable to his people of his religious background, he was there. He was part of the discussion, and it's kind of indicative of when you talk about the promissory note of that is contained in the Declaration, that this was going to be a nation of many religions, many peoples eventually, and there's something interesting and encouraging in that too. But I can't choose just one.
Do we have questions from the audience?
Sure. So starting with FDR, as we said, like the states lost a lot of rights. The federal government kind of continued. We saw through about 80-90 year period with Roe v. Wade, just a lot of federal decisions. Do you think after the Dobbs decision that it's going to start swinging more towards states' rights, or do you think that there's going to be such a pushback against that there will be more federal government power and regulation, and where do you see that going over the next 25 years?
It's hard to make predictions, especially about the future, as Yogi Berra would tell us. There's two different components, right? One, in Roe, you had the Supreme Court making up a right, asserting a power it didn't have. With the New Deal case, it was the Congress, the executive branch, and the legislative branch asserting powers they did not otherwise have. I think the courts have to play a role in ensuring those limits exist, but I think those are two distinct problems. In the wake of Roe, I think what we've seen is now the states are actually engaging what Judge Sutton will call experimentation. And Ohio's had referendums on abortion, Michigan's had referendums on abortion, and states start filling out how they're going to regulate this issue. As for limiting federal power, I don't know that work could be overturned. I think even Justice Scalia wouldn't go quite that far in the Raich case. But I think the court's at least seeing perhaps limits on delegation to the major question doctrine. They're sort of policing those outer bounds. I think that's as far as they'll go. See what happened with the tariff cases here. Good question.
Other questions from the audience?
Yeah.
Do you think that we will ever recover even just a shadow of the privileges or immunities, or is that just totally beyond reach?
Beyond reach. I mean, it's sad. In McDonald v. Chicago, this was a case with the Second Amendment. The question was, how should we incorporate the right to bear arms? And I think everyone from Justice Black on agrees that the right answer would be the Privileges or Immunities Clause. That's the right answer. The Due Process Clause is not the font of incorporation. Only Justice Thomas would go this far. There was another case involving, was it Timms versus Indiana, about the Excessive Fines Clause, but whether that should be incorporated. And again, Thomas was like, let's use the right clause, let's use PRI. And Gorsuch kind of hinted it, but he was kind of, just a little curious maybe, and didn't go all the way. I think the court will basically say that's water under the bridge. Whether it's due process or PRI, it makes no difference as a practical matter. Although it would make one difference: citizens. Only citizens have those rights, and I think some of the liberals may not want that on the court. So I think the short answer is no. But what's curious is after Dobbs, go back to the prior question, substantive due process is dead, dead, dead. One of the concerns about the PRI clauses that could lead to substantive due process, I think now we have a cleaner path, but Lochner's not coming back. I'm sorry, it's just not going to happen.
Yeah, five or 10 years ago, you couldn't go a week without a Federal Society program talking about the Privileges and Immunities Clause. So it had its sort of moment, I think,
Yeah.
probably spurred on by Justice Thomas, but it's not talked about quite as much now, and so I think I concur mostly with what Josh said.
I think,
Yeah.
I think those are both probably right as a matter of prediction. I'll just say, you never know. I mean, there was a period in, early in the country's history where you couldn't possibly have predicted that the Constitution would be interpreted to mean some of the things, as you said, that it was interpreted in the Warren years. And even in almost to the early 2000s, you couldn't have predicted some of the decisions today that are more originalist in nature. We talked at dinner about how you couldn't have predicted that Humphrey's executor might be overturned, as it could possibly be this year. So you're probably right, but I'm not taking bets.
To go back to the declaration, it's a promissory note. It's there, it's in writing. Maybe one day it'll come to fruition.
I think that's a good place to conclude. So thank you to the panel, and thank you all for listening.
Thanks, Chad. Thank you, sir.